Hey folks, my name is Shaunak Darup. I'm an attorney, a litigator, and a partner at Arns Davis Law in San Francisco. And today I'm going to talk to you about what exactly is legal precedent. To understand precedent, you've got to understand what the common law system is. In the United States, we're under what's called a common law legal system. Now, we inherited that from the British. And in fact, a lot of English-speaking countries around the world have common law systems. A common law system is one that's based on judicial precedent. The judges, the courts, they make decisions about the law, and those decisions have the force and effect of law. And that's compared to a civil system like what France has, where you have the law as it's written, and for the most part, while courts will make decisions about the law, those decisions are really applied to the factual circumstances in front of the courts. By the way, fun fact, 49 of the states in the United States are under the common law system, except for Louisiana, because Louisiana was a French territory, and so it inherited France's civil law system. And while Louisiana is still bound to the common law system when it comes to federal law, a lot of the parts of its state law have been inherited from the civil law system and operate very differently than the other 49 states. So if you're watching this video and you think you're going to understand how law works in the state of Louisiana, watch another video. If you're going to watch this video and understand how the law works in the 49 other states, then keep watching. Precedent is all about a court's decision being binding on future courts. And that seems kind of simple, but it's a little bit intricate because of the way our court system is structured in the United States and the different levels and jurisdictions of courts that we have. So let me give you an overview first about what the court system looks like in the United States. You all have heard of the U.S. Supreme Court, which is the highest court in the land. The U.S. Supreme Court's decisions bind everybody. And then you have federal and state systems. Because the United States is a federalist system, we have got two concurrent sources of authority, and those can sometimes clash. And so you've got the U.S. Supreme Court, and all the courts, state and federal, are underneath that. And that's where they diverge. You've got then the Federal Circuit Court of Appeals. So under the federal appellate system, the Court of Appeals is a system of district courts. So again, you've got at the lowest level, the trial courts are the federal district courts. And that's where you and I, where people go, and that's where their cases are processed and go through the system. When there's a decision that people want to appeal, it goes up to the Federal Court of Appeals for that district. If I'm in San Francisco, the Federal Court of Appeals is the Ninth Circuit. If I'm in Texas, the Federal Court of Appeals is the Fifth Circuit. If my decision at the Ninth Circuit is unfavorable, I can appeal it further to the U.S. Supreme Court. And then the U.S. Supreme Court will make a decision. That is how the federal court system works. We then have the state system. Every state has its own state constitution, its own way that it organizes its state courts. And so in California, we have a state Supreme Court, we have the Court of Appeal, and then we have our trial courts. They're called superior courts, and they're organized by county. How do those two interact? State courts interpret state law, federal courts interpret federal law. But it's a little more complicated than that because you can file cases in federal court that implicate only state law. For example, if there's a diversity of parties, if someone from California is suing someone from Texas, even if they're suing them under California law, they could bring that lawsuit in federal court because it's sort of like the federal courts are supposed to be the arbiters of clashes between people in different states. So no one has a home court advantage, so to speak. You can also bring certain federal law claims in state courts, and that's called concurrent jurisdiction. And it's all confusing. I mean, we write so many motions and we go through so much briefing to argue with other attorneys about whether the case is properly brought in federal court or state court, or whether the court that we're in front of has the jurisdiction or the authority to rule on those, that even lawyers can't agree on it. Obviously, there are very specific laws about how federal and state courts interact and when a federal or state court has jurisdiction to hear a case. And that's maybe another video because that will take a whole half an hour. Suffice to say, you now have an idea that there are these two parallel but interrelated systems of courts in this country, all leading up to the U.S. Supreme Court. So back to our discussion about precedent. There's a doctrine called stare decisis. When a court establishes a precedent, it is binding. It's binding on that court, and it's binding on every other court within that court's umbrella of authority, within that court's jurisdiction. So a U.S. Supreme Court decision generally is binding precedent on every court in the country, state and federal. You go to a much lower level or much more specific level, for example, a California State Court of Appeal. A California State Court of Appeal decision is generally only binding on the superior courts in California, the trial courts that are that level lower than the state appellate courts. A federal district court sitting in San Francisco, even though it's in California, because it's part of the federal system, the California appeals court, technically a higher level than the district court, because they're in two separate systems, the California appellate decision is not binding on the federal district court. It's not binding precedent. It's not binding authority. It can be, however, persuasive. And so this is the difference between binding authority and persuasive authority. Here's an example. In California, the laws around whether somebody is exempt or non-exempt employee, which is whether they're entitled to overtime, those laws as written, those regulations, they mirror very closely the federal regulations on whether someone is entitled to overtime or not. They were written in a way that sort of drew from the federal regulations. And so when a court in California, a state appellate court, makes a decision interpreting the California exempt, non-exempt overtime laws, it is not bound by federal court decisions interpreting the federal regulations about exempt and non-exempt overtime laws. Even though the laws are written very similarly, the federal decisions are not binding precedent on California state appellate courts. However, they can be persuasive, especially because the intent and the language of the regulations is so similar. A California Court of Appeal can look at a decision where factual circumstances were very similar to the case it has and say, that federal appellate court in Illinois wrote about a factual circumstance very similar to the facts we have here. And although the law they were interpreting was the federal regulation and not the California state regulation, I think that because the laws are very similar, the reasoning of that federal court is very strong, and I should apply the same reasoning to this case. And I will reach the same outcome, and it is logically and legally sound. And in doing so, the court can basically adopt that or follow that reasoning, even though they don't have to. And that's an example of how authority from a different jurisdiction can still change the law in a certain jurisdiction because it's persuasive. So that's precedent, binding and persuasive. And as you can probably tell from this, precedent has a huge impact on the laws that you have to follow. When I'm litigating a case and I'm trying to figure out how to bring a certain claim, how to get past certain defenses, how to craft a legal argument, I'm looking at the law as it's written a fair amount. But I'm looking at cases interpreting that law a ton. I'm spending most of my time researching and reading those cases because those cases are going to tell me how that law has been interpreted in factual circumstances similar to mine. It's going to tell me what certain parts of the law mean. I mean, laws as written can be confusing sometimes. And it's sort of by design because laws are ultimately the product of a compromise. Laws only get passed when a certain number of people in your legislature and your executive agree on the language of the law. And because of that, sometimes you can get laws that are not the clearest. So then courts undergo the process of statutory interpretation, interpreting statutes. And that may mean interpreting a single sentence in a statute, a single comma in a statute, or an entire section of a statute to figure out what it means so that future courts will be able to apply the statute in a consistent way. The vast majority of legal argument then happens by analogy and distinction. I want to analogize my case to all the cases where the outcome was similar to the outcome I want. And I want to distinguish my case from all the cases where the outcome was the opposite of what I want. And in doing so, I want to tell the court, Your Honor, the facts in our case should go into this bucket where all these courts ruled in this way. And that's why you should rule in this way too. And they are not in this bucket because here's why each of those cases were different on the facts. Sometimes you get into arguing about what the law should be. These are called issues of first impression or novel issues. They are factual circumstances that have cropped up in a way that has never been seen before in the context of a particular law. And so the court is being asked to apply a law that was never applied to this factual circumstance to this new factual circumstance. And it's very hard then to say this case fits in this bucket of old cases. You still argue by analogizing to those old cases, but it's a little bit more of a persuasive argument of this is how the law should be expanded just a little bit to fit the facts of this case. And doing so would be totally consistent with the way courts have ruled in these other factual scenarios. It's the reason why if you're arguing, for example, something about the Commerce Clause of the Constitution, you can take old railroad cases from the 18 and 1900s and talk about them in the context of your case having to do with internet communications. It's not that the internet is a railroad. It's that you're saying to the court, back when these railroad cases were decided under the Commerce Clause, by the way, the railroads were new, and courts had to interpret this 100-year-old, 200-year-old document, the Constitution, in the context of no railroads, this new technology. The reasoning that the courts underwent then is still sound reasoning today, just as applied to the internet. Now, there are times when courts disregard precedent, and it's not a decision they take lightly because courts don't want to upend the very foundation of our common law system, but there are times when it's warranted. And we can talk about it in the context of the Supreme Court because it happens every now and then. Since the Supreme Court is the highest court in the land, there is no higher authority than the Supreme Court. So it makes sense that every now and then the Supreme Court might have to overturn its own precedent. There are two general reasons why a court, the Supreme Court, for example, will decide to overturn its own precedent or not follow its own precedent. The first, and the most common, is times have changed. The societal values at the time this decision was published are no longer society's values today. Linked to that is also the science has changed, the law has changed. We just know more now than we knew back then. How we look at things are different now. A great example of this is Brown versus the Board of Education, the case that held segregation was unlawful and unconstitutional. The years before, the Supreme Court had issued a decision called Plessy versus Ferguson, and that was a decision in which the Supreme Court said separate but equal was constitutional. And that's really what cemented segregation. When the Supreme Court issued its decision in Brown versus Board of Education, the court said society has changed in the way it looks at racial discrimination. The science has changed in the way we look at the impacts of segregation on Black individuals and on society. And because of that, the court said separate but equal is not equal, and segregation was unconstitutional. Great example of the Supreme Court not following its own precedent. Same thing happened in Obergefell versus Hodges when it overturned Baker on the issue of same-sex marriage. The other reason that courts may disregard their own precedent is judicial error. Now, we just got it wrong. This is much rarer, but it can happen. Probably more often if the makeup of the court is entirely different than the way it was back then, right? You have entirely new judges who are looking at this and saying, wow, the judges who were here 150 years ago got it wrong. You know, when I talk to my friends who aren't lawyers, and I'm so steeped in this world for so long about precedent and analogy, distinction, and all this stuff, but my friends talk to me and sort of are like, well, why do we even have to do that? I mean, why can't we just take the law as it's written and apply the law? And there it is, clean and simple. Why do we have to bother with like getting into what 50 courts have said and how that changes things and like nitpicking about words in laws? It all seems a little bit nitpicky, lawyerly, you know? And they say it with like that face. It's a little lawyerly. And I always try to say, no, there's a perfectly good reason. And I don't just say that because of job security and because I think I have a great job and I love it. No, I really believe it. I think there's a really good reason for interpreting laws and being technical when it comes to the language in laws, and why precedent is so important in courts interpreting even specific words in a statute. I have a great example for you. This is the Bostock versus Clayton County case. This was a case in 2020 That was brought under Title VII of the Civil Rights Act. Title VII is about employment discrimination. And let me read you the specific language from the statute. It shall be an unlawful employment practice for an employer to discriminate against any individual because of such individual's race, color, religion, sex, or national origin. That case was brought by a plaintiff who was fired from his job for participating in a recreational softball league that happened to be a gay softball league. He was fired because of that. And the question was his firing discrimination under Title VII? The legal question was he fired because of sex? Under Title VII, you can't discriminate against somebody because of sex. He was discriminated against because of his sexual orientation, because of his sexual preference. And the legal question was, in the meaning of that statute written in 1964, does because of sex mean because of sexual orientation or sexual preference? Why does it matter? Half of you watching this video right now are saying, of course, because of sex means because of sexual orientation or preference. It's a no-brainer. But I bet that a bunch of people watching this video are saying no. Because of sex means because of sex. Because of sex means discriminating against somebody because they are a man or a woman. In 1964, when Title VII was drafted, it was highly unlikely the drafters intended to prevent discrimination on the basis of sexual orientation, because the topic of sexual orientation was both taboo and also not within the common collective consciousness as it is now. The drafters most likely simply intended it to prevent discrimination against men and women in jobs. So how do we apply that law to the facts here? The first place to go is the plain language of the statute. What is the statute saying? And if you can resolve the issue, if the meaning is clear from the plain language of the statute, you go no further. You don't need to, because the statute says what it means and it means what it says. Now, if the statute is ambiguous or unclear, then you go to a different level, the next level, right? You go to the level of the intent and the purpose. And you can dig into what the drafter's intent was. Sometimes folks will look at other things written around the same time as that act was written and how certain words were interpreted back then in other areas. They'll look at the notes from the legislative committees and the congressional sessions of that bill to see what people were saying about the bill on Congress floor to figure out how it should be interpreted now. But if the plain language is clear, you don't get into any of that because the plain language is clear. And in this case, what Justice Gorsuch said, leading a 6-3 majority opinion of the court, was that the plain language of the statute is clear. Because of sex necessarily means because of sexual orientation or sexual preference. Because if you are discriminating against somebody on the basis of their sexual preference, who they are sexually attracted to, you are necessarily discriminating against them on the basis of sex, because sexual preference requires an element of a person's sex. It's the person they're attracted to. That derives sexual preference, sexual orientation. And so you can't take the sex out of sexual orientation. And for that reason, the court found that discrimination based on sex includes within it discrimination based on sexual orientation. That's one word, and it's an interpretation of one word. And there are many people out there who believed and who argued that that's not what the law meant, but it's what the law means now because that's what the Supreme Court has decided. That is binding precedent. And that has a huge impact on every other court in the country, not just in how those courts interpret Title VII. When those courts interpret Title VII, the Supreme Court's decision in Bostock is binding precedent. They must interpret Title VII to mean that discrimination on the basis of sex includes discrimination on the basis of sexual orientation. But what about laws that are similar to Title VII, but not exactly the same? What about state laws like FEHA in California, the Fair Employment and Housing Act, that also prevents discrimination? Because Bostock is persuasive authority for other laws that are not FEHA, courts can look to Bostock and look to how sexual orientation and sex was interpreted and use the same reasoning in cases that involve statutes that are similar to but not the same as Title VII. And in this way, a decision by the Supreme Court about a single word in a single federal law has huge ramifications on every other law that is even loosely based on Title VII, and there are many of them in every state in the country. And that's a perfect example of why the words in statutes matter, why it matters that courts can and do interpret those words, and the impact that that interpretation can have on every arguing precedent, arguing by analogy and distinction, researching laws, and making the argument as to why certain facts should fit into certain buckets and why courts should follow certain cases and why they're similar and why they're different, and harmonizing all that precedent and weaving a line through it. That's really the art of legal argument. It's frankly what makes it so fun. It's why I love it. It's a giant, unending puzzle that constantly has new pieces and constantly changing. It's also the reason why it matters that your lawyer is a good lawyer. I'm all about not gatekeeping the profession of law or the legal system. I think the barrier to access to justice should be as low as it can be so that everybody can get through and navigate the legal system. It does take a significant amount of experience to figure out how to find these precedents, how to read these precedents, and how to apply these precedents in a way that is persuasive and authoritative and can convince a court to rule in your favor or to expand the law a little bit. It's one of the reasons why I think the law can feel so inaccessible, because it isn't enough to just know what the letter of the law says. You sort of have to know how courts have interpreted that law, and you have to be able to find all of the ways in which courts have interpreted that law in situations that are similar to your situation. In a perfect world, the barrier to justice would be non-existent, and everybody would be able to access it. And certainly, tools like AI are making that barrier lower and lower every day. But there is a place still for attorneys who have the experience and the knowledge to go through and make those kinds of arguments, because they take skill. And when you can make a good legal argument, you can persuade the court to rule in your favor if the facts line up with what you're trying to argue.